Ladies and gentlemen, welcome to today's webinar. Today's seminar topic is everything you need to know about attorneys' fees and costs awards in Florida Guardianships. Our presenter today is attorney Teresa Phillips. If you'd like a copy of today's presentation, you can find it in the handout section of the webinar interface. Similarly, if you have a question, you can type it into the questions section of the webinar interface. And now let me hand it over to Teresa. Go ahead, Teresa.
Hi, thank you, Tony. Good afternoon, everyone. Welcome to the seminar. I apologize for the rescheduling due to an illness issue last week, but I'm back and excited to discuss this issue with you today. Guardianship fees is for anybody who is involved in this area or has become involved in this area of late. You'll recognize that it's not the most enriched, codified kind of law that you'll find in regards to what are the procedures, the criteria, and things with regards to attempting to get fees and costs reimbursed in guardianships. There's really just two primary statutes that you'll ever deal with, and from there you have to glean it from the case law and glean it from sometimes with comparisons to probate and other areas of law. Why is that? It could be a number of reasons. As I think I noted in a recent webinar, guardianship cases are on the rise significantly. All the counties are reporting, an uptick in those filings in the last few years. Now, one of the most basic explanations is obviously there's more seniors with the baby boom generation, but there seems to be a much more trend to turning to guardianships to assist in certain areas. And then with the recent, issues that got a lot of publicity, you have the Fearley matter here in Central Florida. Years ago, you had issues going on down in Palm Beach County, Hillsborough, Pasco County that got a lot of attention. So when you get things like that, I think you'll see more and more attention paid to this. You'll see more people pointing out in legislation that into the legislatures that there's a lot of issues that haven't been fully resolved, fully codified. And gives a lot of room for interpretation and discretion, and that you may see some changes is my prediction in the next few years. So until then, we're tasked with reading through the statutes, reading through the amount of case law we do have, which isn't tremendous, but it is somewhat helpful and usually very fact intensive. And a lot of it comes from the second DCA, which is your Hillsborough, your Pasco counties, Pinellas, that area. And then put it all together and then use that when you advise clients on what their chances are of being reimbursed for fees, and of course using it when you actually attempt to go and recover fees. Now the fees I'm going to talk about today, as attorneys or practitioners, we're used to dealing with attorneys' fees and seeking reimbursement. But in the context of guardianship, you're also seeking reimbursement oftentimes for the guardian, and that could be a guardian in a lot of contexts that we'll discuss. And you also have other third parties that are interested in incurring fees, such as examining committee members and things like that. So what we're going to be talking about today is a little bit more broader than just attorneys' fees, even though that is always a driving part of all of this. And in your role as an attorney who represents a ward or a guardian or another interested party, you may find yourself having to advocate or for or against fees for different parties. So it's good to have a good broad base. So with all that in mind, let's go over our agenda so you can get an idea of how we're going to try to break this up. The first area we're going to talk about today, we're going to talk about the interested parties. The interested parties that are in an incapacity and guardianship fee or cost reimbursement petitions. Who are those parties that are interested? We're going to go through that. It's not just the attorneys, the ward, and the guardian in some cases. Next section is going to be the legal authority in support of payment and reimbursement in incapacity proceedings or guardianship proceedings. Petitions for fees and our cost reimbursement. That will be the third section we'll talk about. What has to be in the petition? What are the statutory requirements? What are some other issues to consider when you're preparing and filing your petitions? Number 4, what are the factors to consider in determining fees for guardians and attorneys? Those are primarily statutory, and we'll go through those. Then we're going to take a time in Section 5 here to look at some local administrative orders. In Florida, we have 67 counties, 20 circuits, and in some of those counties and circuits, they have rules that kind of address fees and costs. Some of them have maximums, they have set fees, they have a little bit more guidance on what can be reimbursed, and some of it's just for the examining committee, some's for the guardians, professional and non-professional guardians, and in some cases attorneys. And so let's look at those and see how those might affect how you might handle certain guardianships when you're in that sort of situation. The sixth topic we're going to look at overall is the practical tips for the practitioner. After we've gone through all this, I'd like to circle back and let's try to pinpoint and note some holes or some fact patterns that might not be answered by everything we've reviewed, and how maybe you might want to handle those and maybe think about those when you're going into a guardianship matter, depending on the facts of your case. So I hope today you learn about the law, you learn about maybe some practical aspects of what you might want to consider, and you might find out that there's some really odd rules out there in some of the outer counties and circuits that maybe you don't practice in, but maybe you should be aware in case you ever find yourself out there. I'll try to hold at least 10 minutes at the end so you can have any questions. I also like to welcome any comments at the end. If you have a scenario that you've encountered, and, that you'd like to share, I certainly am a practitioner that like to hear things like that. And I think it's very helpful, and especially in an area like this where there's some gray area. So with that, let's move on to Section 1. Let's look at interested parties. In the context of guardianships, an interested party status is fluid and is dependent upon whether the person would be affected by the outcome of the proceedings. There's some law on that. I've cited 2 cases there for you. And the Wheelers versus Powers is a 50 CA case. And so that means that if you can articulate or demonstrate how your client or this party will be affected by the outcome of the proceeding, in theory, you're an interested party in that particular proceeding. In the context of guardianships and probate, as an aside, that can be fluid as well, because you may normally be an interested party in the probate proceedings, but there could be sub proceedings in there that maybe you're not an interested party. Maybe you're interested as a creditor on things that affect you, but maybe not. A creditor, maybe, or someone that needs to be paid in a guardianship context. Let's say you've got an outstanding fee petition, an examining committee member, an attorney. Maybe you have a right to be noticed when other people want to get paid, or other people want to use, or other parties are looking to use income for certain purposes, but you're probably not an interested party on a petition to move residence or things like that. So even within one guardianship case, you may not always be an interested party for everything that's going on within that guardianship case. So what kind of interested parties do you need to think of when you're preparing your petitions and determining if you need to notice parties? Obviously, guardians are going to be interested parties. I can't think of a scenario where they're not. And in fact, most petitions for fees require the guardians to be noticed. And we have all kinds of guardians. Remember, we have the emergency temporary, we can have a professional, we can have a limited, a plenary, a guardian advocate, a guardian ad litem to do just more tailored duties for the benefit of a ward or alleged incapacitated person. So you may not just have one guardian, you could have numerous. You can also have the guardian, split between person and property. Your ward or alleged incapacitated person, depending on what stage you are in the proceedings, clearly is going to be an interested party. And again, there's a statute that they have to be noticed with any petitions and or their attorneys. You have the attorneys for the guardian. Usually a guardian has someone representing them in the proceeding. They may have attorneys representing them in litigation or things that involve the guardianship. But usually it's going to be, we're talking about the person who's representing them in the administration of the guardianship. Attorneys for the ward. And there's the statute there has an interpretation that an attorney for an alleged incapacitated person means an attorney who represents the AIP. So it's not limited to the court-appointed attorney that you get in guardianship cases when there's an incapacity petition filed. It can be any attorney that represented the ward that may have some interest, either being noticed or maybe filing the petition themselves. There can be attorneys for other interested parties. When you have, if the statute, as we're going to get into in a little bit, is going to say if you render services that benefit the ward, as some key language. So at least in theory, there could be circumstances where attorneys might not represent the ward or the guardian, but maybe they've performed some legal services that benefited the ward, and that they could petition. I just reminded you here, your examining committee members are going to have a right to fees as well, and are going to need to be paid at some point from the estate. And there's different ways to handle that, as we'll get into in a little bit more detail. So we've looked at our interested parties. We've kind of had we're starting to get an idea of who's always involved. Let's look at a few more here. These are not all, these might be your more unusual ones, but you can have joint owners of guardianship property, and they may be interested parties anytime that joint account is going to be used to pay any monies for guardianship fees or costs. There's certainly case law there that I've cited. The Hago-Payan case versus Guardianship of Zimmer. The court held that they are interested parties and should receive notice whenever there's a proceeding that may require payment from a joint account. That's something to keep in mind. Number G, subsection 2 and 3 here kind of go together. There have been circumstances that I've seen where, the judge has found the next of kin, especially those that are beneficiaries under a will, may be an interested party in property decisions and disbursement of property and or liquidation of property, things like that. So I don't think it's a stretch to say that they may be an interested party for purposes of determining if fees or costs should be paid from guardianship assets. And then and you can have creditors. Oftentimes the creditors are like examining committee members who are still waiting to be paid, or other attorneys who are waiting to be paid. And they certainly would have an interest in it if you're seeking to have payment made from a certain account, especially in the case where maybe there's limited monies. So that I've tried to touch on what you would potentially see as an interested party. Obviously, given the broad definition, it can vary in the circumstances. And if anybody has another interested party that under an odd circumstance came to play, please feel free to tell us or mention it in the questions at the end of the broadcast here. So let's move on to section 2. What's our legal authority that we're going to use to support any reimbursement or payment of incapacity proceedings or guardianship proceedings? There's two statutes that you're primarily going to rely upon. That's section 744-108 and section 744-331 subsection 7 of the Florida statutes. Between these two, you're usually going to find, your authority for seeking your fees to be paid or reimbursed, or costs to be paid or reimbursed, whether you be a guardian or attorney or examining committee member. So let's start looking through these statutes. Let's start parceling them up a little bit and looking at different situations where you may rely upon them. The first one is going to be guardians. Guardians are going to be entitled to a reasonable fee. And that's for services rendered. And then they're also obviously going to be reimbursed for costs they incur on behalf of the ward. Now, when you get into the case law on this, they look at what guardians are entitled to, and it's not really so much as how much of a benefit it may have conferred on the ward. The services, it's more, was it within the scope of your duties? Was it something that you were supposed to obligated, or or was part of your good faith duty to act as the fiduciary here, or the scope of your services within that gambit? If they were result level of benefit is not going to usually say that you don't get the fees. The courts can look at that to maybe reduce the fees or determine what would be a reasonable hourly fee for those kind of services. But the thing you want your guardians to do, the case law that disallows guardianship fees, is usually when it's not, you were performing things that's not really in the scope of what a guardian does, or whatever the scope of your authority was as a guardian in that particular proceeding. Your basis for it, your legal basis, is section 744-108. Subsection 1, a guardian or an attorney who has rendered services to the ward or to the guardian of the ward's behalf is entitled to a reasonable fee for services rendered and reimbursement for costs incurred on behalf of the ward. Now, to break that up, what I was getting there too is that it's read where a guardian, comma, so a guardian's just separate, then a comma, or an attorney who has rendered services to the ward or to the guardian on the ward's behalf. That portion is just related to the attorneys. So the guardian doesn't have to render services to the ward or on their behalf or things like that. That's just for the attorney. The guardian, what they're looking at, did they perform within the scope of their duties as guardian? So you don't want to confuse those standards. And then both parties, an attorney and a guardian, is entitled to reimbursement for costs incurred on behalf of the ward. Who else may be looking for reimbursement or payment of fees and looking for statutory authority? Well, we just touched on it. It's attorneys who have rendered services to the ward or to the guardian on the ward's behalf. They're entitled to reasonable fees as well. And it's the same basis, 744-108, subsection 1 of Florida statutes. Now, you also have other attorneys that are involved, and that's court-appointed attorneys that are part of the incapacity proceedings, and examining committee members who are appointed as part of the incapacity proceedings. Now, their authority to be paid is under a different statute. It's 744.331 subsection 7. And it reads in pertinent part, the examining committee and any attorney appointed under subsection 2 herein are entitled to reasonable fees to be determined by the court. The fees awarded under this paragraph A shall be paid by the guardian from the property of the ward, or if the ward is indigent, by the state. And then it goes on to say toward the end here, costs and attorney fees of the proceedings may be assessed against the petitioner if the court finds the petition to have been filed in bad faith. So this sets forth the examining committees and the attorney appointed their right to compensation. It provides they'll be paid from the ward unless it's indigent, and in that case the state. And if there's bad faith, the examining committee and attorneys can be reimbursed from the petitioner itself. But you'll notice that's a little broad there. It also says costs and attorney's fees of the proceedings. So it seems to indicate it could go beyond just the examining committee and the court-appointed attorneys in this section. So there's the different type of attorneys who may be involved. I've listed out there for you. There's a court-appointed. You can also have a private attorney. An alleged incapacitated person can decide to substitute their own private attorney in. You can have attorneys for guardians once they're appointed. You can have attorneys for third parties that, in theory, could seek to have reimbursement if they can show they render services to the ward or to the guardian on the ward's behalf. Let's look at subsection C here. Attorneys that can serve as both guardian and their own counsel in guardianship proceedings. That is permitted. And we're back at section 744.108, and we're looking at subsection 3 now. It's permitted when there's no conflict of interest between the two, and when it comes time to pay fees, the court must distinguish what are guardian fees and services and what are attorney fees and services. Meaning that you may charge $300 an hour as attorney, but when you're performing duties as a guardian, you're probably going to get a lot less than that, something more commensurate with what a guardian would reasonably obtain in those circumstances, performing those kind of duties. And then we have a subsection here, who pays the fees? And as we've already seen, it usually is going to come from the ward or the ward's estate. Especially if a guardian has been appointed. As we touched on in the section previously, a bad faith petitioner may be obligated to pay if the court finds that they filed the petition in bad faith. Now, to have a bad faith petitioner, there's some criteria that has to be made. if you read this whole section that deals with this, I'm going to read the whole subsection. If the petition is dismissed or denied, the fees of the examining committee shall be paid upon court order as expert witness fees under a separate section. But costs and attorney fees of the proceeding may be assessed against the petitioner if the court finds the petition to have been filed in bad faith. The petitioner shall also reimburse the state court system for any amounts paid under a separate subparagraph upon such a finding. So you need to have the petition has to be dismissed or denied, and then there has to be a finding made that the petition was filed in bad faith, and then the fees and costs can be assessed against that petitioner. Again, I think the term here, costs and attorney fees of the proceeding, is pretty broad, and can perhaps can not just be the fees and costs of the examining committee or court appointed, but maybe someone else that also was involved, maybe a private attorney and things like that. Okay, so now we know who our parties are. We know who may be seeking reimbursement. We've got an idea of what authority they're relying upon to seek that reimbursement. We've kind of highlighted where we should be thinking where we're going to get these fees from and get them paid from, what sources. Now let's look at if we're going to file a petition, what needs to be in our petition, whether it be a petition for fees or cost reimbursement. See, the first one, and again, we're going to be looking primarily at section 744.108. And the first thing, as with any petition, notice must be given to all interested parties. The ward and the guardian are always interested parties in fee petitions, and that's subject to section 744.108, subsection 6, Florida statutes. It must be accompanied by an itemized description of fees and services, section 744.108, subsection 5, Florida statutes. And I've even seen a case where they reversed on the petition that granted the fees because it didn't accompany an itemized description. The petition didn't. The DCA found that in of itself was deficient and should have been denied as facially deficient. And that was even though there had been an evidentiary hearing and there had been testimony that was pretty descriptive about what was being sought. The court said, well, that's all fair and good, and it should probably be done in a lot of cases. That still doesn't keep you from complying with the statutory requirement of subsection 5 here. So don't forget to attach that itemized description of fees and services. Subsection 3, I've been asked this before, can you charge for paralegal and staff work that work under the supervision of a lawyer? Yes, you can. 744.108, subsection 4, Florida statute says you can. It can be part of the attorney's fee reimbursement for the staff that worked under that attorney. It needs to be itemized and described in your petition what fees are attributable to paralegals and staff and what rate they're charging for such fees. Subsection D, the time period covered and a total of any previous fees, costs awarded to a guardian or attorney. And we're looking at section 744.108, subsection 7 here. Unlike any probably fees that you file in any other context, such as litigation, divorce, things of that sort, guardianship specifically requires you to keep a running total of all fees and costs that have been awarded to a guardian or attorney in the proceedings when you go back to seek more. So if you're on your second petition, because you're 6 or 7 months into the guardianship and you incurred some more fees since you initially requested, you specifically have an obligation to put on there not only what you're seeking for this petition, but what's been previously awarded by the court. Why? I'm guessing because it helps keep the court aware of the bigger picture of how much is has been awarded to date. It gives the court an idea of what kind of fees have been awarded to date, and helps them in determination of an overall reasonable fee. And you got to remember, in guardianships, they can last years, and court judges change, and it's a good way that they keep on tabs with that. Again, if you don't include that, it can be denied as being facially deficient pursuant to 744.108 subsection 7. So now we know what our petition has to look like. We know who we have to notice, any interested parties, and that always is going to include the guardian in the ward. So we've got our petition filed. We've met all the statutory requirements, a nice itemized list there, all the things we just went through. Now, what's the judge going to consider in awarding or determining the amount of fees for guardians and attorneys? Again, this is part of the statute 744.108, subsection 2, and there's a number of factors here to look at, and we'll go through them. I think most of them aren't going to be of a surprise to you and self-explanatory, but let's go through it. The time and labor required, the novelty and difficulty of the questions involved, and the skill required to perform the services properly. Again, if it's something simple and the attorney did it when a paralegal could have done it, or maybe it wasn't even something that required attorney work, maybe that's something as simple as going, loading up the storage facility with the guardian's things. Attorney's probably not going to be reimbursed for that. Maybe even a paralegal, probably that's more of a guardian work, things like that. So the court's going to weigh those kind of things. Number 3, the likelihood that the acceptance of the particular employment will preclude other employments for the person. This will probably come more in play when you have a professional guardian or an attorney, if that is so consuming that maybe it affects how much they can spend on other things. 4, the fee customarily charged in the locality for similar services. In my experience, the courts rely upon this more than anything. In my personal experience, there becomes an idea of what the area will support and what fees are customarily charged. And I find this to be an overriding factor in a lot of cases. Number 5, the nature and value of the incapacitated person's property, the amount of income earned by the estate, and the responsibilities and potential liabilities assumed by the person. If it's a lot of property, there's tax issues, there's liability issues with property, managing the property. Obviously, that's probably going to justify a higher fee, a higher hourly rate for the guardian, maybe a higher attorney rates fee, more specialized fees that are going to be needed to advise and perform the functions. If it's a simple guardianship where the person's being cared for by a professional home or service or facility, there's very little day-to-day activities other than setting up the bills to be paid by auto pay. The guardian's probably going to have a harder time to argue that they should have a higher fee. If they're having to constantly meet with accountants, financial advisors, dynamic markets, there's a business that, is a small business that may be family-owned business that the guardian or the ward has an interest in that they have to oversee, go to board meetings, things like that. You could see where the fee might have to be adjusted to account for those kind of things. The results obtained, again, I think that's more in the attorney context. But it is something to be considered in the amount. Let's see, the next one, the time limits imposed by the circumstances. I think that one's self-explanatory. The next one, the nature and length of the relationship with the incapacitated person. That comes into effect, just a note real quick. The courts have found like a guardian of the person, if they have a familial relationship, let's say a mother and daughter, a father and daughter, there's things that the daughter would do whether they were guardian or not. They're going to go visit more often than what's required minimum for a guardian. They're going to go see them in the hospital. They're going to do things that they were going to do that as part of that familial relationship. And the courts will usually discount or disallow fees for those kind of things because that's not really part of their guardianship's duties. It's because that's the normal relationship between those kind of parties. Now, if you have a circumstance where they didn't have a close relationship and the person's only going to do these things because they were appointed guardian, I guess that's an argument to be made. But the case law I've seen on these matters, the courts cite that they're not going to allow anything that normally a person would do with that kind of familiar relationship. It also comes into play in context where you have parents serving as guardians of kids' property and things like that as well. There's certain things that parents not only are supposed to do, but legally are obligated to do that have nothing to do with their guardianship responsibilities. The last one here that they've listed statutorily is the experience, reputation, diligence, and ability of the person performing the service. This is probably going to come in more context of professional guardians, maybe guardians that are lay guardians, not professional, but maybe they have some kind of expertise. Maybe they do tax work. Maybe they've been a caregiver, a nurse, something like that. That means that they have a really, high level of performance here, and the court can determine that they should be compensated in a certain way to account for that. Do you need expert testimony? In most contexts of attorney's fees in the civil realm, you need some kind of expert testimony to justify attorney's fees as a matter of law. That's not the case here in guardianships. And you can cite section 744.108, subsection 9 as support for that. What it says is the court may determine that a request for compensation by the guardian's attorney, a person employed by the guardian, an attorney appointed under another subsection, or an attorney who has rendered services to the ward is reasonable without receiving expert testimony. Now, a person or party may still offer expert testimony for or against a request for compensation, but they have to give notice to interested parties. Also, something to note here, in the probate context, in the guardianship context, unlike a lot of other contexts, especially in civil law, the fees for determining fees are recoverable. Subsection 8 here of statute 744.108 says when court proceedings are instituted to review or determine a guardian or an attorney's fees under this section, such proceedings are part of the guardianship administrative process and the cost. So this is one of the contexts where you can get potentially reimbursed for fees for seeking fees. And then I just left here other factors that the court may consider. And sometimes this is by experience. Some judges are going to pay attention to certain things, and we all learn that as practitioners. Some are going to be interested in, how well the guardian's doing, or I'm sorry, how well the ward is doing, how overall, how good the financials are being handled, how his portfolio's looking, how frugal maybe the guardian's been. There's all kind of things that they can look at. In addition, this is not an exclusive list. It is a list they have to consider, but there could certainly be other things that they want to take a look at. Another thing the court may be pressed with, and I pose this question: how about a percentage fee? How about if an attorney has proposed and with his client, the guardian, that he or she be paid a percentage fee? That's not anticipated under section 744.108. Contrast that with the probate statutes that actually contemplates and that being a compensation model and method based on the value of the guardianship, both for PR fee and for the attorney's fees for the personal representative in a probate. Can you do that in guardianship? And I don't know what the answer is. I mean, it's certainly not. It's not expressly prohibited, but it's not specifically permitted either. The way I would approach it, and what I suspect a court would approach it, is they would look at the overall fee and still look through these criteria and see if the fee falls within that. But that's something that could be an issue at one point if someone decides to charge a fee based on percentage. Again, the court's going to look at those normal family relationships and discount anything that they think that you would have done as a layperson anyway for the ward, fairly or unfairly, because they may not do that for the guardian, a professional guardian, but they're going to discount anything that they see as a function that would normally be served by someone in that kind of relationship. Also, examples or issues that might come up when the court's considering what to award. Can you argue that someone's waived the right to a certain fee? the statutes and the law does allow guardians to waive, but it has to be expressed in an express waiver. Can attorney's fee waive? I have found case law where where maybe unartful language and settlements have seemed to suggest that that perhaps the attorneys agreed to take a certain amount in the guardianship proceedings and didn't say what happens going in the future if there's other fees, and then that attorney ended up not having any more fees, the court finding that they implicitly waived that going forward because they didn't in any way address fees for the future. And the case I cite to rely upon that would be Guardianship of SAP. It's a second DCA case, 868 Southern 2nd 687. This was one where you had a child being a guardianship for a mom. And this was the one I mentioned earlier also, where they got they reversed because there wasn't an itemized list attached to the petition. So so just be aware that if you think there's been a waiver, that can be an issue that's brought up before the court. So let's get into something maybe a little bit more fun. Let's look and see how some courts look at these things. I pulled some examples. I mean, we're dealing with a state with 67 counties and 20 circuits, so you can have a whole plethora of different administrative orders and local orders. And there's nothing that prohibits those as long as they're not in contradiction to the statutes. But you certainly, if you're practicing in a county, you want to see if there's certain things. I have been in circumstances, not in this area, but other circumstances where judges had particular rules and things that they just had like criteria or issues that they wanted the practitioners that come before them to be aware that they consider when looking at petitions for fees and costs. And it would have things on there like what they found to be lately of a range of fees that they found to be the prevailing fee range in the area, and things like that, just so that when you brought your petition, if they found the prevailing fees to be $200 to $400, don't bring in a petition for $600 an hour, or at least be ready to explain why that should be allowed. It wasn't a hard, fast rule so much as just some criteria to be aware of, and I found that very helpful. Like I said, I think that was in a South Florida case. It wasn't around here, but I found that be very helpful. And if especially judges that are doing exclusively guardianship, they're in a guardianship, circuit and division, and that's all they're doing. Things like that can be extremely helpful. Otherwise, we kind of figure it out as practitioners the more times we appear before that attorney, I think. But here's some districts and jurisdictions who've come up with some local administrative orders that limit and have hard, fast rules on fees. Let's start looking at some. This is from the 5th Judicial Circuit, and this one actually has gotten some scrutiny and some question as to whether it violates the statute, because it's pretty pretty specific and pretty hardcore in limiting fees and setting fees, and doesn't give a lot of room. And people have questioned whether this can be stricken because it sort of takes away the duty of the court to review those criteria and apply them to every case. But let's go through some of the key provisions here that you might find interesting and think of, and of course would be helpful if you ever find yourself in the 5th Judicial Circuit. One of the things they have here is guardians who meet the qualifications of a professional guardians will be treated as a professional guardian. And then they allow the professional guardians, it says, shall be paid at a rate of $65 per hour. And professional guardians with 5 years or more experience will be paid at a rate of $75 per hour pro rata for all reasonable and necessary work performed for all guardianships which qualify them pursuant to as professional guardians. They're citing the statute. So this gives essentially a flat rate to guardians whether they've been practicing 5 years or less. It's either 65 or 75. And as you can see, there's really no room there to increase it or decrease it depending on the circumstances. Subsection 3, all other guardians shall be paid at a rate of $15 per hour pro rata for all reasonable and necessary work performed by the guardianships. So whether you're a guardian that's a nurse, doctor, maybe have some specialized skills that sometimes we see the courts take into account for compensation, it would appear under this rule that wouldn't matter. You're going to get $15 an All billing shall be in increments of 1/10 of an hour. They also have a requirement here that prior to payment, all guardians are required to apply for and obtain court approval by petition. Now, there's no rule that says you have to do that in the statutes. It's considered good practice, because what happens if you don't, and later on you do your yearly accounting, if there's fees in there and you don't have an order to approve them, you're going to have to go get an approval then. So, it's good practice if you're going to have to get court approval anyway, to get it beforehand before you actually make the payment, so that you're not forced to pay back to the ward's estate. So paragraph 6 here says petitions will be reviewed by the court or its delegate in order to determine the reasonableness of the time spent. So they do allow the court to cut the amount of time, or maybe increase the amount of time. I'm not sure, but they certainly don't give any leeway here about the rates, and they do allow reimbursement for mileage for guardians. And then subsection 9 here clarifies there's no leeway. The rate of compensation shall apply to all compensable services rendered and costs incurred as of the date of this order. So that's, in my mind, that doesn't give you any leeway to change the rate of compensation other than what's delegated in this order. So if you're down in up in the 5th Judicial Circuit, make sure you're aware of this. Palm Beach has a rule, an administrative order here. Let's take a look at what Palm Beach says. One of the things I took from here, they do require an affidavit to accompany the petitions. And so that's not something that's necessarily required by the statute, but here they've asked that a petition for attorney's fees, it's right here in paragraph 1 in the middle, must be accompanied by an affidavit addressing the pertinent considerations set forth in rules regulating the Florida bar, supported by an itemized schedule of time and effort, which shall be served upon the counsel for the guardian. So of course the itemized schedule is required, the service on the guardian is required, but this affidavit that, essentially saying that you're charged a reasonable and fair fee is something that's not required by the statutes per se. They also go through to set up an examining committee member fee schedule. Those are not unusual in the circuits, in the courts, even though they usually allow maybe some leeway if you can argue why you should get more. And then they have the examining committee members, and depending on their different, what they're doing, if they're doing a flat fee, and then if they're doing time such as testimony, which as you can see in this paragraph 2, payment for testimony is capped at 2 hours total. This has become important since now you can't just enter the reports as evidence unless that's agreed upon. So you have to ask these committee members to come into court, authenticate their findings in person, and it's hard to do that if they're only going to get the top fee or the flat fee. I want to point out subsection 3 here. The court administration shall pay the fees of the examining committee members in the event that the proceedings are dismissed because 1, the alleged ward is found to not be incapacitated and the court finds a finding that the petition was not filed in bad faith, or the alleged ward dies prior to determination of incapacity, or the proceedings are dismissed prior to a determination of incapacity, but after the examining committee has completed their evaluations. These are some, and what I like about this actually is I think it's trying to contemplate some of the areas where things happen that the rules don't really provide for, and you might have an examining committee member end up without being paid, and those can be tough situations. For example, out here, what if it's dismissed because there is an incapacity, but there was the petition was filed in good faith? The ward's not going to have to pay because the alleged ward is not incapacitated. There's no guardian appointed to pay the examining committee, so they're going to be stuck trying to seek reimbursement from the state. So they anticipate this here. This is a situation that actually was in the case law. The alleged ward, there's an incapacity petition filed, and presume it's in good faith, but the ward dies before there's a determination. maybe they've already, examined and they've already incurred fees, and now there's no way to get reimbursed, at least through our statutory scheme. And here, if the proceedings are dismissed prior to the termination of incapacity, but because they've already completed their evaluations, maybe it was dismissed because for a number of different reasons, but not because of death. So they do provide for the examination committee members being paid here. I want you to remember that, because at the end here, we're going to look at situations. What about if it's the attorney? How about if attorney's fees have been incurred and things like that? A court-appointed attorney has incurred fees. And what if these situations happen? Where do they go to get paid? Okay, here's another example I put up here. This one's from Pinellas and Pasco counties, 6th Judicial Circuit. And you can look through those. This is administrative order dealing with a lot of different kind of cases, but you'll see here that they do eventually get to where they're in the incapacity and guardianship cases. They've got some rules here. But I know our time is starting to run low, and I wanted to save time for questions in case there were some. So I'm going to move on to wrapping things up, but I want first to talk about practical tips for a practitioner. What I was just looking at and what I will allude to here, what about situations where there's been attorney's fees incurred, there's been good faith, a court-appointed attorney, things of that sort, but there's never a guardian appointed for whatever reason. The statute contemplates, as we read from Section 744-108, that these things will be paid from the ward estate once a guardian's appointed. So what happens when they're not appointed? Can the examining committee and maybe the court-appointed attorney only rely upon the state? Or if there's a court administration rule like we saw there in one of the circuits or one of the counties in Palm Beach County. It really does, it's open-ended, and it's not really an answer to a lot of these things. And it's sort of accepted as a risk when you're going to be on the examining committee list or a court-appointed list. And I have news to tell you, in some counties, smaller counties, you're not always voluntarily on those lists. The judges expect you to be available for things like that. So that's something to think about. One of the situations I have here, how about insolvent guardianships? What if you go into a guardianship thinking it's got plenty of assets to pay all these parties? There's a guardian appointed, the guardian and attorney in good faith start incurring a lot of fees and costs because they're starting to marshal the assets and they're just getting started, and the person dies and the guardianship and their authority over the assets ends, and they can't do anything, they can't take any more action in those roles as guardians, but they've incurred a lot of fees and costs in anticipation that the assets would be used to pay, and now there's nothing, but there was nothing collected in time to actually use to pay them. What happens in those circumstances? What if you have some money? Maybe you have a little bit of money you collected, but you have a lot of fees. You have the examining committee, you have the court appointed, you have the attorney for the guardian, you have the guardian. How do you divide those up? So do you do it pro rata? Does one have priority over the other? I've not found anything directly on point, but I think you can argue, there's one way to argue maybe the probate priority system, maybe it should be pro rata. I think you could argue equitably, one is more important than the other, and maybe they should take first, and set up your kind of a pro hoc priority system. Those are the arguments you can be made, but what I think is certain is there's no statute that really contemplates this, and I've yet to find any case law that really fills in the blanks here. So those are things to think about, and maybe you encounter that case, and one day maybe we get some good case law or firmed up case law on that, or maybe the legislature is brought to their attention and they start filling in some of these holes in the statute. Another practical tip that I want to discuss, and we kind of talked about prior court approval or approval from interested parties. It's not per se required before you pay yourself, but I certainly would get court approval, and or at the very least the interested parties. Why that's not determinative for the interested parties, I think it would help the court, if there's no objections, it doesn't do away with the court's obligation to review and determine for themselves that it's reasonable fee, but it certainly helps from other objections being made and having to anticipate the costs associated with having to fight those objections or testimony and things like that. C, record keeping. In guardianship, it's tempting because you're busy to forget to record keep. Not the attorneys, we're used to it, but guardians. Guardians will do a lot of work that they don't write down. And then later on, when there is a scrutiny on their fees, and the court asks them, what did you do? What exactly did you do this day that incurred 5 hours? You just have here, visiting and doing this. If they have more details, that they had, drove this far, this many miles, spoke to so-and-so, it will help. It will help them because you don't ask for these reimbursements every month. You ask for them months or maybe a year down the road, and you will forget. So being in a good habit of record keeping will make your life better as the guardian, and certainly your life as the attorney who represents the guardian. So I hope this has given you a good, better understanding, a little bit more detailed and better, closer look at what goes on in these cases, some of the issues you have to look at. Again, thank you for your time, and it looks like as we have no questions that we'll just wrap this up now. Have a good afternoon. Be safe.